Aloha, I am John Roth, and this is Just Ask John, where I, an estate planning attorney, answer your estate planning questions. Today, we have Leola Augustine. She is the BIC, the broker in charge, here at the Hawaii Life Kona Real Estate Office. Thank you for joining us today.
Thank you for having me. Hello, everybody. This is going to be fun.
So we have a real estate expert to talk about how to hold title to your property.
You know, there's actually a good scenario that I recently came across that I'd like to run by you and see if that's something that you can help out with. So I've got a family. I've got Mr. Aloha, Mrs. Aloha, and then Keiki Aloha.
Ooh.
They're all buying a beautiful home here in Kona. They were asking me about probate. Should something happen to them, both of them at the same time, what's going to happen with Keiki Aloha? How do they protect his interest? What happens with probate? So what would you say to that Aloha family?
So when talking about real estate, it goes hand in hand with talking about probate, because when you die with real estate in your name, probate is triggered if there isn't anyone else on title with rights of survivorship, or you don't have a transfer on death deed. That property triggers what we call the probate process. So a lot of people are interested in avoiding probate, and a way to do that for Mr. and Mrs. Aloha would be, first of all, if one of them dies, if they hold the property joint tenants with rights of survivorship or tenancy by the entirety, if one spouse dies, the other spouse would just automatically become the owner through rights of survivorship. If it's tenants in common between the two joint owners, then when one owner dies, their interest does not automatically go just to the surviving joint owner, it triggers probate as well. So it's very important to look at whether the property, when you hold it joint with a spouse or joint with anyone else, to know whether it's tenants in common, joint tenants with rights of survivorship, or tenancy by the entirety, because rights of survivorship will allow the survivor to bypass the probate process.
So you brought up a term that I've heard, but I've only heard it once or twice in my career. And you said a transfer on death deed, which luckily thankfully have not had to work with that. But can you explain that a little more?
A revocable transfer on death deed is a deed, it's kind of like a designated beneficiary provision. So if you have a retirement account or a life insurance policy and you have a designated beneficiary, when you die, the designated beneficiary automatically, as soon as the death certificate is provided to the financial institution, the designated beneficiary just gets a check in the mail, bypassing any sort of estate administration like probate.
Okay.
So a transfer on death deed, just as soon as you record a death certificate in the Bureau of Conveyances, whoever is designated as the beneficiary on the transfer on death deed automatically becomes the new owner without having to go through the probate process.
Okay.
So another thing between Mr. and Mrs. Aloha with Keiki Aloha is how they want to hold property during their lifetimes. A lot of times my clients, when they want to update their estate plan, and so they purchase a property and I look at the deed and it's joint tenants with rights of survivorship, which means the surviving joint owner, the surviving spouse, would just automatically become the owner if only one spouse died. But tenancy by the entirety is more ideal, and it's only an option for married couples who own property together 50-50. It allows for more asset protection because it protects the property from creditors who only have a claim against one spouse. Joint tenants with rights of survivorship does not have that asset protection. So when individuals come to my office and they're specifically in the process of buying real estate, they have a real estate agent like yourself representing them, a lot of times the question becomes, do I need a trust? Do I need to hold off on this escrow until I have a trust? At what order does this happen? So I explained to them that they can purchase the property as an individual and at any time later transfer it into their trust. You know, there's exceptions, it's just the general rule. They don't have to have the trust before they purchase the property. Once you have a trust, it's like an empty basket, or now the cloud. It's with you the rest of your lifetime, and you can put things into it or take things out of it. Ideally, if you're trying to be as efficient as possible, you have the trust first, and when you buy the property, you buy it as the trustee of your trust, so it just automatically becomes a part of your trust as soon as you purchase the property. And if you have a mortgage, the note is also made out to the trust, so everything is aligned.
I guess it's the same thing with An LLC, it's an entity. A trust is an entity. An LLC is an entity. So you can either have it set up prior to the transaction, you can have it set up during the transaction if the transaction is long enough, or you can set it up after the transaction and then have everything transferred in there.
Exactly. So that's a good analogy between an LLC and a trust. So thank you for joining us, Leola. This has been great.
Thanks for having me.
We are here at Hawaii Life Kona office with Leola Augustine, the broker in charge here. If you have any questions, please comment below or go to our website at hawaiitrustlaw.com.
Thank you.